Hi, everybody. Nice to see you all today. This is Karen Tereposky from Samfiru, Tumarkin. I'm a lawyer, an employment lawyer in the Calgary office of our firm. And I'm here today to answer any questions you might have about employment law. So hopefully we get some good ones and we'll wait for those to start coming in. I guess while we're waiting for my first question to appear here on the right side of my screen, we can chat, I guess, a little bit about some of the things that are happening in the world. And I guess we've all heard about Donald Trump's plans with tariffs. Looks like there's a 25% tariff coming in on steel for Canada, and I guess that could affect some jobs here in Canada. Really, once that production or that industry takes that hit, is it going to be a situation where people get laid off? And if that affects you, what can you do about it? And what rights do you have? I guess one thing people might wonder is whether or not, if a government action leads to them losing their job, or does that affect their rights? Does it make their rights any different? And really, probably not. Your rights would still be the same outside of where that government action would actually cause what we call a frustration of contract. So if the government action actually would prevent your employer from operating their business to the point where they couldn't give you a job, then it might be a frustration of contract, which would mean the contract just ends, basically, is what frustration is. It just ends, and through no fault of either party. So that was kind of like what happened in COVID, sometimes with the vaccinations. What happened there with some employers was that they were not allowed on sites unless their employees were vaccinated. So if it was a third party coming onto a site controlled by someone else, they couldn't bring employees on who weren't vaccinated. Basically, they couldn't employ you if you weren't vaccinated. So that was a frustration of contract. So it wasn't just a decision by the employer that you need to be vaccinated, but it was something that they couldn't control, was outside of their control, that caused them to not be able to employ people. And that made the contract frustrated. And in those situations, employees really weren't entitled to any severance. And in Alberta, where there's a frustration of contract, there's not even anything owing under the Employment Standards Code. In some jurisdictions there is, like Ontario, for example. Even when a contract is frustrated, there is still some statutory pay owed to employees, but in Alberta there isn't anything. So it's not a great situation, but it's pretty uncommon, really. It has to be a situation where it really makes the contract incapable of performance. So if it's a choice by the employer, then that doesn't equal to frustration. It has to be something out of their control, which makes it literally impossible to continue to employ an employee anymore. So yeah, with those changes to the tariffs coming in on the steel industry, it could be something that could affect a lot of people's employment. I would say for the most part, most people are going to have the same rights as normal, which would be your right to severance for a wrongful dismissal or for your termination of your employment contract. So generally, if you are employed in that industry and these tariffs do affect your job, it would be great to give us a call. And if you lose your job and you have a severance package that needs to be reviewed, we can obviously take a look at that for you and let you know what your rights are, and whether you're being treated appropriately or whether you should push back. So if that happens to you, don't hesitate and reach out to us. I do have a question coming in. The first one here, it's from Reddit. It says, my girlfriend went on stress leave from her job this morning. We found out that her company let go the entire Canadian team as of this afternoon. Is her employer allowed to let her go while she's on leave? Will this affect her EI sick benefits? So, is her employer allowed to let her go while she's on leave? So in some jurisdictions, like in Alberta, there is a job protected leave for 16 weeks that you can take. There are some requirements to get on that leave, which is like you have to put in a medical certificate and give your employer the date that you return. So if you followed those requirements, or if your girlfriend did, then she's entitled to be protected on her leave, and there she is supposed to be brought back. However, there is an exemption to that if the entire operation is being shut down. So if they would fall under that, it is possible that that job protected leave wouldn't apply in her case. The other piece that you want to consider is whether the employment ending has something to do with the disability or the reason that she's on a sickness leave. And if it does, then there could be a human rights component to it. But if there's a shutdown of the whole operation, it's likely that the employer could prove that there's nothing related to the sick benefits. Regarding whether it should affect her EI, it shouldn't. Those benefits are there while you're directed to be on sick leave by a doctor, so it shouldn't. Obviously, you have to contact EDSC and make sure, but I would say it shouldn't affect those benefits. She should still be able to continue to get those for as long as she's eligible. So hopefully that answers that question. We have another question that came in that says, can an employer lower hours of pay in anticipation, hours or pay in anticipation of loss of work? So employers can change the terms of your employment contract or your compensation to an extent. If it's in anticipation of loss of work, I mean, it doesn't really have to be any reason, but I guess that would be a valid one. But if they are wanting to change your hours of work or your compensation, they can do so on notice. And it just has to be enough notice. So if it's an immediate change, that would not only violate the terms of the Employment Standards Code, but it also might amount to a constructive dismissal if it's a big enough change, if it's unilateral, and if it's without notice. So it depends on how they've done it. But as I said, if it's right away, if it's a big change, and it's not done on notice and it's unilateral, or she had no or you have no input into that change, then it could be a constructive dismissal, which would entitle an employee to severance in that circumstance. So there's a few things that would need to know to answer that question completely, but generally they can meet requirements, they can do that, but if those requirements aren't met, it may be a situation where you could seek severance. So I have another question that has come in from YouTube. I am currently off on maternity leave. My original return date was January 2025, but my doctor has requested I stay off until June due to medical concerns. This has all been sent to my employer, but now they are requesting to meet with me. Should I have the meeting? What do I do if they let me go? Well, if your employer is requesting to meet with you, you probably should meet with them. If your medical restrictions are to the point where that would be a problem, you could ask to meet virtually or have a phone call. But in general, if an employer wants to have a meeting with you, shouldn't refuse it. They may just want to discuss, your return, or, there may be, like you've sort of predicted here, what do I do if they let me go? Maybe they're thinking of terminating. If they are, I just mentioned the job protected leave under Alberta employment standards. So that could be a violation of the Employment Standards Code, because even if you were off on maternity leave, if you've started a new medical leave, you have 16 weeks in 2025. So your maternity leave might have gone till January 2025. But if you submitted a medical note with a return to work date or a predicted return to work date, that 16-week job protected leave would kick in right now. And really, unless they wait until that 16 weeks is up, they would be violating the code if they do terminate you. So if they do let you go, hopefully they would offer you something as severance. And you need to get that looked at by an employment lawyer, because although they might be violating the Employment Standards Code, we really can't make them stop. All we can do is get you a good severance in that situation. So, contact us, have us look at it. We may be able to get some extra damages for that violation of the code. There's potential to make an employment standards complaint, and we can walk you through all of that and figure out what the best option is based on, what that severance letter says and what their offer is to you if it is a termination that's coming up. And hopefully it's not, but if that is the case, please reach out to us and get some good advice. So hopefully that answers that question. And now we'll move on. We have another question from YouTube. Oh, no, that is the same question. So there's another different question from, I think, looks like YouTube as well. If my employer says they're investigating a serious matter involving me, do I have a right to know what it's about? It's been over a week and I was only told not to talk to coworkers. So at some point during the investigation, if they're investigating you, they need to talk to you and get your side of the story. I have had several employees, though, that employers don't do that and then terminate them for cause based on the outcome of the investigation, which, really that's not a proper investigation if they haven't got your side of the story. So they should be asking you about what happened, and, it's part of the investigation to get your side of the story. I guess, do you have a right to know what it's about? I guess that would be what happens when they bring you in to investigate. I don't know that they have a right to tell you exactly what they're investigating initially, but if they are going to, use it as a reason to discipline you, if it's a with cause termination or just a suspension or whatever they'd have to do in order to get to that discipline, they should be interviewing you and asking your side of the story in order to properly investigate it and get to an informed conclusion. They can't really do a proper investigation without talking to everybody who was involved. So I guess, at that point is when you have a right to know what they're investigating so that you can tell them, what your side of the story is. Okay, we have another question here. Can an employer move to a different location and expect staff to follow or consider them resigned if not? So again, we might get into a frustration of contract situation here, depending on why they're moving to a new location, which is what I was talking about before. But I mean, again, with a unilateral change to the terms of your employment, right? If you're working in Calgary and they suddenly move to Edmonton, and they expect you to come with them, that would be a unilateral material change. Like, that's a pretty big change to the terms of your employment if you live in Calgary and they're going to make you move. So if they don't talk to you about it, don't give you notice, don't, have you agree to come with them, I don't think it would be proper for them to say that, well, you've resigned if you don't come. Likely what would happen is that, if you refuse to change locations, they would have to terminate your employment without cause. Subject to, what I was talking about earlier with the frustration of contract. If the reason that they're abandoning that location is out of their control, then, it's a possibility that there'd be a frustration. It seems like a remote possibility in this case where, they're just moving to a different location. Now, whether that change of moving to a different location is a material change to constitute constructive dismissal would kind of depend on how far it is, right? If they're moving from Calgary to Edmonton, then, that's probably a pretty material change. If they're moving from, one side of the street to the other, probably not, right? So there's sort of varying degrees of whether or not you can consider it a material change and whether that means there's been a constructive dismissal of your employment. But if we knew more facts, we'd be able to tell you kind of a more solid opinion on that. But just in general, I would say likely not, depending on what that change is and how they're going about it. So I'm sorry, there's my dogs trying to join in. They've got some opinions too. Okay, so next question on YouTube. I've been working for a small family company for the last 5 years or so. It's a general contracting company. Due to a lack of work, they told me they would no longer need me. And because we work in trades and they're a small company, I'm not owed any severance. Is this true? Well, the size of the company definitely has nothing to do with whether or not you're owed severance. General contracting, sometimes if you're a construction company, there is a exemption under the Employment Standards Code where they don't have to pay severance in certain, well, not severance, so they don't have to pay termination pay under the Employment Standards Code in certain situations. So that does not mean that you're not entitled to common law severance, though. So I think generally the answer to this question is no, this isn't true. Because you work for a general contractor and because it's a small family company, that doesn't exempt them from having to provide proper pay in lieu of giving you notice of termination. So it could be that you have that you're subject to an exemption for termination pay under the Employment Standards Code if you are working in construction on site, which might be what this is if it's general contracting. But that does not necessarily mean that you don't qualify for severance, which is common law pay in lieu of notice or what the courts would award. So that might sound confusing, but basically, I would talk to someone about it. 5 years if you don't think you can find other work right away, and you could be entitled to something pretty significant there. So reach out with that question. I'd say too, if you want to see kind of what you might be entitled to, you can try our our severance pay calculator or Pocket Employment Lawyer. That's going to give you an idea of, how much that they might owe you. You put in some factors, your age, your years of service, et cetera, and it'll tell you what you might be entitled to. And then you can evaluate whether or not, it's worthwhile to come talk to one of us and get you some advice. A lot of times we do free consults initially. So if you do qualify for one of those, then, that's good enough for, it doesn't really need to be a big amount to make it worthwhile. But yeah, check that out. So another question on YouTube. No, that's the same question again. I got to try to read those through before I do that. Okay, another question. If you worked for a US-based employer, are there things you should know if they start treating Canadian staff differently? What kinds of laws affecting Canadians working for US companies? Okay, well there could be a lot of things there. So that's kind of a mouthful. I guess, are there things you should know if they treat Canadian staff differently? Well, whether or not the company is based in the US, if you are living in Alberta, you are subject to Alberta employment standards laws. So if they're treating Canadian staff differently, I guess I would need to know in what way, and differently from, I guess, their US staff. There may be reasons why they're treating Canadian staff differently, because maybe different laws apply. What kind of laws affect Canadians working for US companies? Again, if you live in Alberta, you're subject to Alberta employment standards. So your minimum standards are under Alberta law. With your employment contract, if you signed a written employment contract, sometimes when they're US-based companies, they have you choose the US law in that contract. And there's some factors as to whether or not that choice is actually even effective. So it depends on a lot of things. And I apologize that that's kind of a typical lawyer answer, that, it really does depend on a lot of things and how your employment contract is structured, whether they have a Canadian operation and you're working on site, whether you're working remotely, what kind of work you're doing. So, I mean, generally though, if you are working in Alberta, even if you're working remotely, you are subject to Alberta employment standards. Some jurisdictions in the US have what they call employment at will, which means they can just fire you and they don't have to pay anything at all, no matter what. And sometimes when it is a US-based company that is in one of those jurisdictions, they try to impose that on Canadian employees, and that doesn't work. You can't do that. Somebody who lives in Alberta cannot be employed at will by a US company just because the company is in the US. So, if you have questions about an employment contract and want to take a look at that, it would probably be wise to get that reviewed before you're signing off to make sure you're not giving up any rights under Canadian employment law. If it's a situation where you've been let go, or, something is happening in the course of your employment, I think we would need some more details about what's happening in order to advise you on what laws you need. So, if there's more to that, I would encourage you to reach out and try to get some specific advice on that, because what I've said is pretty general. So I have another question that's coming from Reddit. We have an employee, so this is an employer side question. who seems to be experiencing some sort of psychotic break. He is threatening staff and saying very unusual things. As an employer, what should we do in this situation? Is there someone we can call to have him checked out? It seems wrong to just kick him out if he is suffering. Yeah, you have to be pretty careful about this as an employer, because if there's a suspicion that there's a mental health issue or an addiction issue, which would be a mental disability or a physical disability, there can be a human rights ramification if there is an adverse effect in his employment from having these symptoms. So you have to be pretty careful about it. You may want to talk to the employee about whether or not he needs assistance. Does he need accommodation? Does he need time off? Does he need something that's going to help him out? At some point, the employee would have to tell you that there's a disability, but I would say what you're describing probably gives rise to the duty to inquire under human rights law to ask whether or not there is some sort of accommodation he requires, and to figure that out. But obviously, I mean, if it is a safety issue, you're justified in removing him from the workplace or sending him home. Even under human rights law, if there's an adverse effect in employment due to disability of some kind, there is a test for whether it was reasonable and justified in the circumstances. So if there's a safety issue and he's doing some things that are pretty scary to other employees or customers, you should be able to ask him to remove himself from the situation, but also find out if there's something that needs to be done for him, and monitor that situation closely. It's pretty tricky. So, if you need to talk to somebody more about specific things, please reach out. We do some employer side work at our firm. We talk to a lot of employees, but we talk to a lot of employers too. So feel free to call in. Okay, so another question on YouTube. My employer has a history of terminating people who make any complaints. I'm dealing with workplace harassment and don't know what to do. I'm worried that if I say something, I'll be fired. What should I do? Well, if you are experiencing workplace harassment, the first thing that you need to start doing is documenting all of it very carefully. Either keep like a journal of some kind. And I know, today we like to keep everything electronically and on our computers and everything, but just keep in mind that if your employment is terminated, you lose access to your computers right away. So, you can use your computer to do that. But if you are, make sure you're taking pictures or something. Try not to be emailing to your personal account from your computer, because that can get tricky too. What might be best is to have a notebook and just write in it. Sometimes old school is best. So, write down any incidents that are happening so that you can document them going forward. If there's any emails or anything that you're dealing with that are harassment, take pictures of them with your phone so that you have those for later on. Ultimately, if you're afraid to make a complaint, you're probably, looking at something that may be a toxic work environment, which could be a constructive dismissal, and that can entitle you to severance. It's as though you're being dismissed from your employment, although you actually aren't, but it's the employer breaching the terms of the employment contract by not providing you with a safe place to work. Also, if you do complain about workplace harassment and your employer does terminate you, there can be a complaint under occupational health and safety legislation, because that's just not allowed under occupational health and safety legislation. It would be considered an illegal reprisal. So really, they can't do that. And if it does happen, you should definitely come and see somebody, and we'll see if we can get you, under occupational health and safety legislation, they actually can reinstate you. It's kind of a long shot, but, I'm not sure you'd want to go back there if you're getting workplace harassment issues. But, we can look at what kind of severance that you're owed and try to get that for you and give you some advice. But I think at this point, if you are experiencing workplace harassment, the most important thing for now is honestly to make sure you're documenting everything, so that if you need it later to establish that there's been a toxic workplace, that times and dates and names and exactly what was said. And if you are keeping track of things right when they're happening, that's really good evidence for later on if you're in court or whatever. If you wait a week and then go write it down on a piece of paper, it's not as good. So, if something happens, write it down right away, put the time in, put the place, all the details that possibly can document, so that number one, you have that record, and it can also refresh your memory later on to exactly what happened. So who was there, where it was in the office, what was said, etc., like time, everything. So as many details as possible, and just keep track of any incidents. It's really important. Also with, employer having a history of terminating people who make complaints, I don't know who it is that you're looking to make a complaint to, but some employers do have anonymous lines that you can call. So check and see if there is something like that. There really should be someone that you can talk to that doesn't, go straight to management and gets you in trouble. But I realize that some employers don't have those things, but just check into that to see if that exists in your workplace. So okay, another question. Can an employer mandate a return to office if I have been working remotely effectively for 4 years? So again, another likely material change to your employment contract. So if that change is being made without your agreement and it's being made like right away, then that's a difficult one for an employer to do without some repercussions, because it's basically a unilateral material change to the terms of the employment relationship, which can be a constructive dismissal. They've just changed your employment contract without your consent. However, there are ways to do it if the employer wants to that are legal and aren't a constructive dismissal. So the first way they can do it is on notice. So actually, maybe I'll deal with the other way first. The first way they can do it is with your agreement, right? So they can say to you, okay, we're going to make this change to your employment contract. We realize this is a very important change and this is a material term. But what we're going to do is we're going to pay you something or give you something for you to sign off and say, yes, I will return to the office. So that's one way they can do it, by getting you to agree. And giving you something in return for that change. So that's the first way. And that applies to not just, a remote return, or a return from remote, but also, a salary change or any material term of the contract. The second way they can do it is on notice. So they can say to you, okay, well, you don't want to agree. So what we're going to tell you is that in 6 months, you have to return to the office. What the length of that period should be, or the appropriate length of that notice period should be, it should be about what you would get in terms of severance if they actually terminated your employment. So, the way to figure out how much that is probably is to use our pocket employment lawyer and calculate that, see how much notice they should be giving you of that change if they aren't giving you any notice, or if they're giving you 2 weeks notice or something. But, if you're a 10-year employee and you're in a pretty high level position and you've been working remotely for 4 years, in order to change that, they would likely have to give you the same amount of notice as, you would be entitled to if they were terminating your employment without cause. So, and that works because basically it's like they're severancing you out through working notice and then bringing you back as a remote worker. And it gives you time in that notice period to go out and look for other work if you don't want to stay. So, so hopefully that answers that, because yes, they can if they want to, and if it's a material change, they would have to get your agreement or give you notice. If they just do it right away, then it's possible that that's a constructive dismissal, because that's likely a material change to your employment contract at this point if you've been doing it for 4 years. Okay, so then. Oh, okay. So this is from the same person. Doesn't my having worked for 4+ years as a remote worker not that make that my regular job? Yeah, it does. But they can change the terms of your regular job as long as they do it properly. And one way is through agreement, and the other way is through notice, right? So imagine they were going to terminate your employment without cause. They would say they'd have to give you, if you've only been there 4 years, they might say, well, we're going to give you 4 months notice, 4 months severance. That would not be a wrongful dismissal probably, because they're giving you enough notice or pay in lieu of that notice that your employment's being terminated. So during that 4 months, or if it's notice or if it's pay, that gives you time to go and replace and find new work. So if they want to change your job, they can say, well, in 4 months, we're changing this term of your job. And it's almost the same as giving you severance, but instead they're bringing you back as a new non-remote employee. So what you get by getting that notice is an opportunity to go out and find another remote job if that's what you want, right? Okay. So same person again, what does proper notice look like if they do it like that? Well, it depends on a lot of factors as to how much notice you would need. So it's the same thing that we look at, when we're looking at severance packages and how much notice people are entitled to. And again, that pocket employment lawyer is a great way to find out how much notice that you should be getting. So what they would do is, write you a letter or send you an email and say, we are going to be returning you to the office from remote work in X amount of months, right? All I know is that you've worked remotely for 4 years. I'm not sure about any of your other factors. So I would say check out that pocket employment lawyer and plug your stuff into there, your factors, and it'll give you a number. And that's probably around how much notice they should be giving you. So of a change. And if they aren't, it's possible that, you might be able to argue that you're being constructively dismissed because they haven't given you enough notice. And if that's the case, reach out and let us know, and we'll talk to you about it and talk you through it and look at all those other factors and find out whether or not, you do have a suitable claim for constructive dismissal. So hopefully that answers everybody's questions today. Really nice to see that a lot of people are still asking lots of things about employment law and that there's lots of inquisitive minds out there. So thanks everybody, and we'll see you again next time.